Good morning. Many thanks for joining us today for our commercial property webinar. We are going to talk to you today about a number of commercial property topics. So first of all, my colleague Steve Jackson will be having a run through the current consultation on the Landlord and Tenant Act 1954 and the proposed changes to that legislation. I will then be running through some rent review tips and potential pitfalls. Adam from Commercial Property will then be talking to you about SDLT. And then we're joined today by one of our employment partners, Kevin McKenna. Given that property development and investment usually requires you to also have employees, we thought that it would be useful to run through some changes to the employer legislation around sexual harassment in the workplace. So I'm going to hand over now to Steve Jackson, who will begin on the Landlord and Tenant Act.
Thank you, Sally. So since the 1st of October 1954, the commercial letting sector has been dominated by one piece of enduring legislation, the Landlord and Tenant Act 1954. This legislation was enacted principally to address the imbalance in bargaining power that existed between landlords and tenants arising from the shortage of commercial property following the Second World War. The Landlord and Tenant Act 1954 grants commercial tenants a statutory right to obtain a renewal lease and continue to occupy a property when their original tenancy comes to an end. This right is known as security of tenure. The Act was amended in 1970 to allow the parties to a lease to exclude the provisions of the Landlord and Tenant Act. This is a process known as contracting out. Initially, this process required an application to court, but from the 1st of June 2004, the process was greatly simplified, becoming little more than a paper exercise. If a landlord and tenant have contracted out a tenancy from legislation, when the original tenancy ends, the tenant will have no statutory right to seek a renewal lease. If the tenant wished to remain in the property, the tenant would need to enter into negotiations with the landlord, who may or may not decide to grant one. The Act has remained in principle the same form as it was initially enacted for the past 70 years. The government have now decided it's time to review the provisions and recently had an initial consultation on the reform of the Act. The consultation closed for comments mid-last week. The purpose of the initial consultation was to consider whether any of the following changes to the Act were desirable. So firstly, the removal of the ability for the parties to a lease to be able to contract the lease out, thus going back to the original intention of the Act. With automatic security of tenure, any tenant can invest more heavily in their business, knowing that when their lease comes to an end, they will be able to make an application to extend their lease. For landlords, this could conceivably act as a disincentive to entering into the commercial property market if the only way that they could regain possession of their property were by potentially expensive and time-consuming litigation. The second option being considered was that there's no security of tenure. This would result in business tenants having no right to renew their lease. In my view, this would be a real retrograde step, allowing the unscrupulous landlord to unceremoniously deny their tenants a new lease at the end of the term or impose such unacceptable terms on them that they would have no option but to move on. The third option is that security tenure which the parties can contract into. This would reverse the position as it currently stands under the Act. This would mean that in each instance, the tenant would need to persuade the landlord to put their lease within the Act, as opposed to it being the automatic position, and would mean that the landlord's bargaining strength would artificially be improved. Tenants would undoubtedly suffer if this were adopted. And fourthly, no change to the current law, the status quo would remain. In my view, having lived with the Act for the last 25 years of practice, I see no reason to fix something that isn't broken. The consultation also addressed the current scope of legislation. It asked whether certain types of tenancy should benefit from the security of tenure regime over other types of leases. And they were depending on, firstly, the duration of the tenancy. So the current position is that any tenancy that lasts for less than 6 months is automatically excluded from the Act. The consultation was exploring whether this period could be extended to 12 months, 2 years, or even 5 years, which would be a dramatic shift from the current position. Secondly, the use of the premises. So the Act currently excludes mining, agricultural, service tenancies, and farm business tenancies. The consultation was exploring whether this list of tenancies should be extended. Thirdly, or the characteristics of the tenancy. So, for example, the size. If the gross internal area of the property didn't reach a particular threshold, it wouldn't fall within the Act. Alternatively, the location. So, for example, in certain jurisdictions, security tenure could be linked to whether, for example, a retail shop is within a shopping centre, or alternatively, the level of rent payable. And fourthly, whether there are competing regimes. So, for example, the Electronic Communications Code, which has provisions which are similar to those within the Act. So once the results of the initial consultation have been considered, a second consultation is likely to follow later in 2025, principally focusing on, firstly, whether changes are needed to the contracting out process itself. Secondly, possible changes to the grounds for a landlord to oppose a renewal. Thirdly, the terms of any renewal lease. And fourthly, the streamlining of the current litigation process. So in conclusion, the revision of the Act, which is the linchpin of all commercial leases and the disputes that inevitably arise from them, will mean fundamental changes in the commercial terms agreed by parties to commercial leases, the way that they're negotiated by solicitors, and the way that the disputes are ultimately resolved. Amendments to the legislation are not likely to be introduced quickly and will hopefully be carefully drafted. It'll be more important than ever to obtain comprehensive specialist legal advice at all stages of the process of negotiating leases and settling their disputes. We have that expertise at Kuits, and we'll be able to guide you through the process once the changes in law are announced. So that's my talk finished. I'll hand you over now to my colleague Sally, who'll pick up the talk.
Thanks, Steve. So I wanted to have a chat to you today about some rent review tips and potential pitfalls. So we sometimes see rent reviews undertaken under the 1954 Act at the beginning of a lease renewal, but what I'm going to primarily talk about today are contractual rent reviews, where the parties have negotiated as part of the terms of a lease a regular contractual review of the annual rent which is payable. So taking it back to basics, we've got various forms of rent review, the most common probably being open market, where the parties will look at some assumptions and disregards around the lease and determine the current market value of that leasehold interest at the particular review date. We then have index-linked reviews, which tie the rental increases to movement in a particular nominated index. We have turnover rent, where the tenant is paying a percentage of the profit attributable to the trade from the premises. And then we have probably the simplest of all, where we have a stepped rent, where it's specifically agreed that the rent will rise to pre-agreed figures at set dates. It's also quite common to see mixtures of all of those. For example, we might see an open market review, but with a fixed base rent. We might see an index-linked review with a turnover top-up. So because of the common use of all of these rent review techniques, it's easy to think that there might be a one-size-fits-all precedent which can be used depending on the type of review that the parties have chosen. But it's really important in each instance to really carefully consider the property that will be the subject of the review and the intended terms that the parties have negotiated with their surveyors at the beginning of the deal. It can be difficult for solicitors to independently determine what each of the decisions made with, for example, an open market rent review will do to the potential value obtainable. And so it's really important for all of the parties to work together to ensure that the appropriate decisions are made. So if I work through some of the usual assumptions and disregards on an open market review, I'll be able to better explain those examples. So on an open market review, we would usually assume that the hypothetical lease is on the same terms as the existing lease, save for the amount of the annual rent, and will then include a hypothetical term for that lease. So will we be using the original term of the current lease? Will we be looking at the unexpired residue of the term at each of the review dates? Or will we go for somewhere in the middle as a compromise? So for example, if we had a 15-year lease, do the parties want to assume that it's 15 years at each of the review dates? Or do we want to go for 10 years? Do we want to assume that it's actual reality, and at the first review it might be 10 years, the second review might be 5 years left unexpired? Now, that's always going to come down to a commercial decision made between the parties, but it's really important to consider in each situation what the impact of that decision will be. Do we want to reflect reality by assuming that all of the lease terms are included? So, for example, we may have a break clause in favour of the tenant. Do we want to assume that that break clause is included for the purposes of review? That may, for example, shorten the term and allow the landlord to charge a higher rent. If we have a landlord preemption option, do we want to assume that that's included in the hypothetical lease? Sometimes a tenant may argue that the inclusion of that makes it more difficult to dispose of the property and it may depress the market value. So it's important to consider all of the specific terms within the lease and determine whether both of the parties want to include all of those within the hypothetical terms of the reviewed lease. Another important one to look at will be the permitted user under the terms of the lease. So how wide is the permitted user? If it's very wide, then that can leave the tenant open to lots of comparables being introduced by the landlord. The wider it is, the more important an impact can be had if there is an assumption that the property benefits from planning for each of the permitted uses. The wider the permitted use, the less likely it is that the property does actually have planning for all of those uses. And so an assumption that planning is in place can be quite detrimental to the tenant. Works to the property carried out by the tenant and the landlord also need to be really carefully considered for the purposes of an open market review. So the usual position would be that a tenant's works, where they've been carried out at the tenant's own cost and in accordance with all of the consents required under the lease, are usually disregarded and not rentalised. But what if the landlord has paid a capital contribution towards that fit out? In all fairness, the parties may determine that those works should be rentalised, and you need to make sure that the terms of that assumption are properly worded to make sure that either any works during the term paid for by the landlord or those specific capital contribution works are included for the purposes of rent review. It can also be really important to consider whether the landlord has done any works specifically for that tenant. So have we undertaken bespoke works? It's quite common on developments of new properties or significant refurbishments for the parties to have a look at how quickly they can get the works done. The tenant may have some, for example, bespoke flooring or a sprinkler system or something which they need to install for their own purposes, but it would actually be easier for the landlord to get their contractor to do it at the appropriate time. And so you might decide to present, instead of going with the base specification that the landlord intended, the tenant may give some bespoke specification to the landlord and they may be happy to provide that. But what do we do on rent review? Do we assume that the property has been handed over to the tenant in the state that it actually was? Or would the landlord prefer to assume that the works that it had originally intended to do had been undertaken? Now, that question will always come back to, what do those bespoke works do to the value of the property? Obviously, if they enhance the value for almost any tenant, then the landlord may be happy to assume reality. But if those works were so bespoke that only really that particular tenant found any benefit to them, then the landlord may wish, for example, to attach a separate hypothetical based specification and allow the rent review surveyor to assume that the property had been fitted out as the landlord had originally intended. This will always come down to a commercial decision, but it's really important to consider the impact of money paid by a landlord, works undertaken by a landlord, and anything unusual that the tenant has been given permission to do. Another point to consider in terms of whether the premises are unusual is, do the premises actually have any comparables in the marketplace? So a number of years ago, I dealt with a lease of a large pharmaceutical manufacturing premises, which were being specifically developed for that tenant. And it was actually the only premises of its nature in the whole of the UK. The parties had originally intended that there would be an open market review for those premises. But actually, when we sought the advice of an expert rent review surveyor, it was going to be very difficult for any comparables to be found for those particular premises, and the parties had to look at some other options. The other way that premises can be unusual is, has the tenant been given an unusual nature of interest in that building? So if you take, for example, a tenant of some office premises, they may have been taking a number of floors within the same building, but the tenant may have asked to take those leases as separate leases of individual floors, just to give them a bit more flexibility for disposal in the future. And the landlord may have agreed to that. But how do we treat that particular interest when we come to the open market rent review in each of those leases? Ordinarily, there would be an assumption or a disregard that we assume that that particular tenant is not the tenant. We disregard their status as a special tenant. But if the landlord has agreed to this flexibility purely for the tenant's benefit, would it actually rather review on the basis that the tenant has one single lease of all of those floors, or that we at least regard their special interest in those other premises? Again, commercial bargaining position will be the determiner, but it's really important to think about whether that tenant has any special interest and what the parties intend to do. Sometimes it's important to look at when is the lease coming into effect. So you can have a number of reversionary leases granted ahead of time where the parties will agree that they will have a day one open market review to determine the rent payable for the initial term of that reversionary lease. That might be some considerable time in the future. So it's really important, rather than just repeating the rent review provisions from the current lease, to really consider, do we need any amendments to those to those terms for the first review under a reversionary lease? So is the hypothetical term that we had in the current lease still appropriate for that reversionary lease, which might be a considerably shorter period of time? And again, just working through, have any of the other terms changed because there is a reversionary lease? Is a break being introduced at some point? And if it is, what do we want to do with that term? That similarly applies to any variations that you might do throughout the term. So you might introduce a variation, but if you haven't considered whether that will be regarded or disregarded on an open market review, that can have unintended consequence when the review comes around with that varied lease. All of the other terms of the lease should also be really carefully considered. So given that the most important aspect of the lease for both parties is usually the amount of rent payable, it's important to consider, are any of the other terms in that lease so onerous on the tenant that they may argue that it makes the lease unattractive to any other party and potentially depresses the market value achievable? Is it really worth imposing that onerous term if it's going to have that detrimental impact on review? So if I move on to index-linked rents, typically these are linked to either the retail price index or the consumer price index. And it's worth noting that it's still intended that the RPI index will be aligned to CPI with housing costs from 2030. Index-linked reviews can be implemented on an annual basis, or probably more commonly, they are implemented on a 5-yearly basis, as with other types of review. But what we are seeing most commonly at the moment is a 5-yearly implementation, but with an annual hypothetical review. And the reason for that hypothetical review is so that a cap and collar can be introduced. That cap and collar is applied on an annual basis, and it just means that the parties are less exposed to the potential volatility of movement in that particular index. It allows the landlord to have a minimum increase and the tenant to have a maximum projected expenditure for the term of that lease. Typically, the caps and collars that we're seeing are around 1% and 5% at the moment. The most common pitfall with index-linked reviews is simple human error with the mathematical formula. So my advice would always be to include a worked example of what the parties intended the rent review to actually do. It can also quite commonly flush out any misunderstanding between the parties. You'd be surprised how many times a simple reference to compounding in the heads of terms can be interpreted differently by the landlord and the tenant. So it's always worth attaching what you intend the formula to actually achieve. Now, everything that I've been talking about assumes an upwards only review. If you are ever agreeing or coming across an upwards and downwards review, that's always a huge red flag in terms of marketability and the availability of funding, and it needs to be considered really, really carefully. So finally, there are just a few miscellaneous tips that we thought might be helpful. When implementing a review, our advice would always be to document that in writing. Even if that is the application of a simple index-linked formula, it's always better to have that written memoranda between the parties when you come to dispose of the property or fund the property. It's always better to have that legal agreement rather than trying to argue, well, the tenant is paying the rent at this new level, therefore they have impliedly agreed that the calculation's correct. In respect of underleases, it's always best practice to ensure as a landlord that you have some kind of reasonable approval of any finalisation of figures under an underlease review. You don't want the tenant to be able to freely set comparables which are applicable directly to the premises. And then finally, tenants should bear in mind that where agreeing rent reviews within the first 5 years of the term of a lease, that does impact the SDLT return required to HMRC. So if there is a review within the first 5 years, it's necessary to make a reasonable pre-estimate of what that review is likely to bring about and pay on that basis. But if in reality the reasonable pre-estimate was incorrect, it is necessary to revisit that return with HMRC. That can be particularly relevant to the example I was giving around reversionary leases. So you may be making a pre-estimate quite a long time ahead of the actual review in that instance, and so those are more commonly revisited. So hopefully some of these tips have been helpful. If you're ever dealing with the implementation of a difficult review or trying to agree terms for a rent review, our team will always be happy to help. So I'm going to hand over to my colleague Adam Himes now, who's going to talk to you about SDLT.
Thank you very much, Sally. That's right. So I'm going to talk about SDLT, stamp duty land tax. Hopefully this piece will be a little bit of light relief somewhat, because I'm looking at a specific case. I was going to cover various pieces of case law, but I decided just to focus on one for ease. And this is a case about stamp duty land tax, SDLT, as I say, which can be a very fraught subject in all property transactions, commercial and residential. And as I say, there's an element of light relief perhaps in this case due to some of the terminology used and some of the specific facts. Anyway, so can just move that slide forward. Yeah, there we go. So as a reminder, move it back. Right, there we are. So as a reminder, there are really only two recognized types of property for SDLT. It's classified in two categories only: residential or non-residential. Now, it will be obvious in many cases which category applies. So, for example, a standard conveyance of a dwelling house with an ordinary garden and attached garage will almost certainly be classified as wholly residential. If you purchase a factory or an office block with no domestic or residential element, you're almost certainly dealing with completely non-residential property. So far, so good. The contentious area, excuse me, is what might be called mixed-use property. In simple terms, unless a property is wholly residential and has a mixed use, then by default it is classed as non-residential property. An easy example would be a single contract to buy both a shop and a house together. As long as it was genuinely a single bargain made between the same seller and buyer, the buyer could legitimately tick the box to declare the property as a whole to be non-residential, or mixed, as some people say, for SDLT purposes. Next slide, please. So why does this matter? What's at stake? So in this particular example, we're looking at a purchase price of £5.75 million. So obviously it's a very substantial transaction in terms of tax applicable to it. Now, under the current tax regime for SDLT, non-residential property often, but not always, attracts more favourable rates of tax than wholly residential property. And I'm ignoring here multiple dwelling relief or other special cases. I'm just speaking in general terms. So the case here, we're looking at a purchase price of £5.75 million. And the tax liability, you can see on the screen there, is massively different. So if the property was classed as non-residential or mixed, you're looking at £277,000 of SDLT, still a large tax bill. But if the property is classed as wholly residential, you can see it's well over £760,000. So a difference of nearly £500,000, £484,250 to be exact, was at stake in this particular instance. If I could have the next slide, please. Thank you. So just as a side note, I will mention a point that it has been some dispute about this mixed use anomaly. So the anomaly that allows mixed use to be claimed, even if the property is almost entirely residential, so that some small part of the lot which is purchased is genuinely commercial, you can still claim a mixed use. Now, this hasn't gone unnoticed by HMRC, and there have been some fairly regular suggestions from Revenue that this loophole might be closed. And the logical approach, you might imagine, would be to require the taxpayer to make a reasonable apportionment between the residential and commercial elements and pay tax on those respective parts. But that's not happened. And because HMRC's approach to residential property is generally much more severe than commercial property due to historic reactions to some perceived or actual abuse of the SDLT system in the early days of the regime, taxpayers have naturally sought to mitigate tax liability if they can legitimately claim any part of the property as being not strictly residential. And that is what the taxpayer sought to do in this case. So why did he fail? What was the issue here? So the bacon factory, as I say, slightly amusing perhaps terminology or title here. So the property in question was a large, significantly redeveloped building in Kennington in London, known as the Bacon Factory. And as the name suggests, it was originally used for industrial curing of meats. But by 2021, it had been sold to a Russian gentleman, Mr. Tretyakov, hopefully I'm pronouncing that correctly, for £5.75 million nominally as a dwelling house. So £5.75 million for a dwelling house that used to be a bacon factory. Well, I'll just leave that there, perhaps, for the benefit of those of us who don't live in the rarefied London property market, but there we are. Now, I will move on to the blurb, which the estate agent put up. I'll just quickly, you can see it on the screen there, but I mean, it's so sort of typical of what you'd expect from the advertising sort of language of the estate agent, but you can see there talking about the property, ground floor, the owner's gone to town, 40-foot private bar and games room, fully stocked functioning bar, the like of which you do not see in a private house. Interesting comment there in light of the tax issue. Gaming table, pool room, bespoke 900 bottle wine cellar, etc., etc. So enough said there. I'll come back to that later in my talk. So, quick run through the history of this building. In 1985, permission had been given to convert the upper 2 floors of the bacon factory to residential accommodation. The ground floor remained designated for planning purposes as light industrial, and had been subject to non-domestic rates from at least 1990 and continued to be the case as at the date of the judgment here. Mr. Stephen, who was the vendor in this transaction, selling to Mr. Tretyakov, he originally rented the upper 2 floors from the previous owner, who used the ground floor to carry on a sculpture repair business. So clearly commercial use there. At some point, the previous owner of the property applied for planning permission to convert the ground floor to residential, so to make the whole building permitted for residential use, but was told that the application would be refused and therefore withdrew their application. Mr. Stephen purchased the entire building in 2016, as you'll see. 2017 and 2018, the building underwent a complete renovation. The property was stripped to a shell and everything was renewed. Now, Mr. Stephen had intended to use the ground floor as a gin distillery connected with an Australian business he'd invested in called Patient Wolf. However, in the end, he couldn't agree terms, so that never actually went ahead. So far, so convoluted, you might say, but potted history there of the building. So the key issue in this case, which was heard in the first tier tribunal tax chamber, was a simple one. The buyer and taxpayer, Mr. Trechikov, accepted that he was in essence purchasing a house, but he maintained, and the tribunal agreed, that part of the ground floor was in fact used for commercial purposes at the point of completion. So what was the issue? Why did the tribunal refuse to allow the taxpayer to declare a mixed and therefore non-residential use? As a reminder, we've got £500,000 of tax at stake here. So it was accepted that part of the ground floor was actually used for commercial purposes. The seller had allowed a connected company to use the front part of the ground floor for the purposes of its business. So all accepted and agreed. It was commercial. So as I say, what was the issue here? Well, the tribunal's view is this. Although we accept that the garage area was being used by Altra, a commercial enterprise who was renting the space from the vendor, between October 2019 and as at the date of sale in June 2021, and that part of the building was not therefore used as a dwelling, that does not mean that this part of the ground floor was not suitable for use as a dwelling. That's a key phrase there, suitable for use as a dwelling, as we'll see. So factors taken into account by the tribunal in coming to their decision, very important points to take away here. Firstly, no modification or adaptation at all would have been needed to use the area in question as residential. So even though it was actually being used for commercial purposes, would not need to modify or adapt, remove heavy machinery or anything like that to use it for residential. Planning was an interesting point. There was a planning restriction actually preventing residential use, which one would have thought might have gone against the argument. But again, the tribunal said, although such use would be in breach of planning restrictions, and you can see the rest of the quote there, but the fact that it could easily have been used as part of the overall dwelling carried more weight than the planning restriction. So thirdly, the remainder of the ground floor was clearly being used for residential purposes, and there was a lack of separation between the front and back. The commercial use was historic, but as I say, not taken into account and had continued. Interestingly, they did refer to the estate agent's blurb that I quoted earlier, which obviously, so to speak, bigged up the residential use of that ground floor and made no reference to the commercial use. So perhaps there's a lesson there to be learned in terms of taking with a pinch of salt what estate agents may or may not say about property. So just to conclude then, what are the takeaway points here? So obviously, do not assume that any element of commercial use within a property or a portfolio, so house plus an office plus other property in a portfolio, even if it's an actual ongoing commercial use, is always sufficient to claim mixed non-residential rates of SDLT. The key question is, can this part of the property be used without much adaptation for residential purposes? The tribunal was very clear on that. Now, I should say that there are other cases, as is always so in the law, which have gone in a different direction to this particular case. So there are a lot of cases which deal with sort of paddocks, land which is an extension of a garden, but the taxpayer claims to be a commercial paddock for the use of grazing horses or something like that if they have a very large garden. Some of those cases have been found in favour of the taxpayer, so that those grounds are held to be commercial use. And that's been enough to argue mixed non-residential use. Again, one could argue those grounds might be easily convertible to use as a dwelling. In other words, you take the horse off, it's not a paddock, it's a garden. What's the difference? Well, you know, that's the nub of this particular case. Everything turns on its own facts. Again, it was, as a final point, it was interesting that little weight was given to the planning restriction I mentioned, and other cases and HMRC guidance seemed to kind of go against that, and that perhaps the tribunal should have considered that there was a planning restriction preventing residential use. But the tribunal ultimately seems to have been swayed by the sort of very blatant, almost ostentatious use of the rear of the ground floor as a sauna, games room, and wine cellar. So, secondary takeaway point: need for expert advice before committing a position or making a tax return, as is always the case with any tax and property matters. So I think that concludes my talk, and I'd like to hand over to my colleague and partner, Kevin, who will be talking about sexual harassment in the workplace.
Thank you, Adam. Yes, I'm Kevin McKenna, and I head up the employment team here at Kuits. I'm grateful to the property team for giving me 5 to 10 minutes just to talk to you about some changes in employment law, which I think will be relevant to you as individuals in your businesses. The next 5 or 10 minutes could save you a lot of money. It might also save your career. So worth listening in, I think, at least for the next 5 minutes. So what are we talking about? Talking about changing some legislation, which is the Worker Protection Amendments of Equality Act 2010, Act 2023. It's a variation to the Equality Act. We've had sex discrimination legislation in place now for a big number of years, since the Sex Discrimination Act of 1975. And yet we still find that sex discrimination and sexual harassment is still prevalent in many businesses. And in fact, it was probably only until recently that we started actually measuring that. There were some simple surveys carried out by the Ministry of Defence in 2008, some European data that we relied upon up until about 2014. But it was in 2016 when the TUC commissioned a YouGov poll to get a sense of the size of the problem of sexual discrimination and harassment in the workplace. And that reported that more than half of women in the workplace who were polled had experienced some form of sexual harassment. Nearly 2/3 of all young women, so in an age group between 18 and 24, had experienced some form of sexual harassment. So the new duty goes further than existing legislation. It's been unlawful to sexually harass for many years, but this is a proactive duty that's been in place now since the 26th of October last year, of a requirement to take reasonable steps to prevent sexual harassment of employees. And it's also accompanied by a statutory code of practice. So I'm going to talk to you briefly about what sexual harassment is and what you need to do about it. So simply put, sexual harassment occurs where both of these things are present. So where a person engages in unwanted conduct of a sexual nature, and I'll come on to what that might mean in a moment, and where the conduct has the purpose or effect of either violating that person's dignity or creating an intimidating, hostile, degrading, humiliating or otherwise offensive environment for that individual. So what might the unwanted conduct be? Well, it can include, and this is a list that's taken from the Code of Practice, it could include things like sexual comments or jokes. Just pausing there and looking back at that YouGov poll, in fact, 32% of all women polled said that they had experienced sexual comments and jokes in the workplace. It could be displaying images, just suggestive looks, staring, leering, propositions, making promises of perhaps advancements in work in return for sexual favours, sexual gestures, intrusive questions about a person's sex life. It could be on people's social media, so it may be in situations which aren't immediately within the context of the direct workplace. Could be spreading rumours, sending explicit messages, or could be unwelcome touching of colleagues. And again, looking back at that YouGov poll, 25% had experienced unwanted touching. And in fact, in a previous ACAS guide on what amounted to unwanted conduct, is not in the current guide, but even making comments to people such as just calling them babe might be go so far as to amount to unwanted conduct of a sexual nature. But the sexual nature is not enough on its own. It must have the purpose or effect of creating the particular environment. If the purpose is made out, then the effect is irrelevant. If that was what was intended, then a tribunal need go no further. Where the conduct is shown not to have had the purpose, then the effect on the individual has to be determined. And this is where I think commonly people get this idea, or at least those who are probably better informed when it comes to issues of sexual harassment, is that it is the recipient's view that's most important. And that's right to a degree, but it's not the only factor that needs to be taken into account. So what should be taken into account is the recipient, and it is typically the woman who is the victim of sexual harassment, their subjective perception, the circumstances of the case, and then there is an objective element, which is whether it's reasonable for the conduct to have had that effect. If those tests are satisfied, then we move on to the next element, which is as to whether or not it created an intimidating, hostile, degrading, humiliating, or offensive environment. And for that, context is important. Timing of things like objections are also important, because you'll remember that what we're talking about here is unwanted conduct of a sexual nature. So that's clearly quite distinct from situations where there are consensual relationships. And so too, then there's an importance of the general state of affairs or the frequency of the conduct that we might be talking about. So the objection, responsibility now on employers is that they must take reasonable steps to prevent harassment. What might that include? Well, the Code of Conduct tells us. So one of the things it will include much more of than we've ever seen before is risk assessments. So there will have been very few Christmas parties that will have been risk assessed since this legislation came in October, but all of them ought to have been. To establish whether or not there are circumstances which might make it more likely that sexual harassment might take place. There should be clear and up-to-date policies in your organisations. You should have effective and suitable training, and that should be taking place regularly. You need to have in place procedures for reporting complaints and concerns. Businesses need to take action. You need to do that promptly. You need to be able to show that you have a track record of dealing with complaints. And then that should be a living document where you are evaluating and reviewing the steps that you're taking as an employer in relation to the events or all of the circumstances that could give rise to sexual harassment in the workplace. Well, why is it important? So I suppose this breaks down into three elements. There's the who is it important to, how much is it worth, and where are the problems going to arise. So the first point there is that it gives rise to vicarious and personal liability. So what that really means, I suppose, is that the business will be responsible for the acts of its employees where that takes place in the ordinary course of work, but so too are individuals. So if you are the person that makes the inappropriate joke or the inappropriate touch in a particular scenario, then you might personally be liable. You would be named as either the first or second respondent in the tribunal case. You might be ordered personally to pay an award. You might find that a decision is posted about you. We'll come back to that in a moment. How much? Well, the first point to make is that the compensation for sexual harassment is uncapped. So tribunals have unlimited powers to make awards to the victims of sexual harassment. The average award last year was £53,403. Awards take into account potentially loss of earnings and injury to feelings. Injury to feelings is a banded award, and currently the banded, so even for the most for single one-off incidents that have the lowest impact on an individual, so that's the lower band award of injury to feelings, would still give rise to an award in a band between £1,200 and £11,700. A mid-band £11,700 to £35,200, and then the upper band for injury to feelings, £35,200 up to £58,700. When you see that figure there of the average remember, that's taking into account not just the injury to feelings, but what might also be the loss of earnings. Many people in these situations find it impossible to return to work after having suffered sexual harassment, and so that's what can give rise to much greater awards. But one of the new impacts through this amending legislation is that there is then the power for the tribunal to increase the compensation that was awarded in what would have otherwise been a sexual harassment case before October. So there's an uplift of 25% in the award for failing to prevent the sexual harassment in the first place. So in a nutshell, it's expensive. We'll come on to and I think that's taking away from the fact that if you have to deal with one of these cases, then there's also going to be legal costs that are also going to impact your business as well. On a practical level, it might also give rise to investigations by the EHRC. There's the danger of adverse publicity. All tribunal decisions now are on a government portal, searchable for your business, searchable for your name if you happen to be involved in one of those cases. For many professions, it's going to have an impact on you from a regulatory perspective, and there is also still the possibility of criminal proceedings. And we've just dealt with a case in the last week where acting for, in this particular instance, an employee who has come to an agreement with their employer to settle the case for in excess of 12 months wages, and within that settlement there will be nothing that prevents that individual from also at the end of that, even though it's full and final in terms of any tribunal claims that there might be, of going to the police to also report an offence. So in terms of how we can assist, well, as you will have seen, I mentioned training. Training is an important element of the factors which are going to be vital to demonstrating that you are taking reasonable steps to prevent sexual harassment in the workplace. We do board level training. We do that for £1,500 plus VAT for an hour and a half. It's the kind of thing that would save you much more than £1,500. It probably a very simple sex discrimination case would cost you probably 10 times that in legal fees, and that's not to mention the awards that we talked about earlier. We also do training then for your employees. That's something that we would recommend. I'm telling you these things because you, by the virtue of the fact that you're on this call with us, you're either a client or a friend of Kuits. You can see for us, probably makes more sense for employers to get into that kind of trouble, and we can make more money out of tribunals than we can out of training. But I think if there was a smart decision that you might make today or this week, it would be to seriously consider some training, review your policies, carry out some risk assessments for any of the events that you've got coming up. That's the end of my section on the talk. I think I'll hand back to Sally now. Thank you for your time.
Thanks, Kevin. So we haven't had any questions come in today, so hopefully everything's been really clear and helpful. If there is anything at all that you would like to follow up on, any questions that you have after the event, or any suggestions for future topics that you might like to see us cover, then please feel free to get in touch with any of us. It just remains for me to say thanks very much for your time and for attending, and we hope to see you again soon.